Доброго дня, шановні колеги. Радий вас вітати в наступній третій сесії нашої конференції, яка буде присвячена питанням оподаткування в умовах
Good
воєнного.
afternoon, dear participants. I'm happy to welcome you at the third session of our conference, which will be dedicated to taxation under martial law. Martial law implies certain limitations to the exercise of rights and at times duties. In the meantime, the state needs continue its operation, which means that taxes need to be paid, need to be collected. Let me remind to the esteemed speakers that the time limit still constitutes 15 minutes. And now let me invite to floor Yevhen Smychok, Associate Professor of the Department of Financial Law at Yaroslav Mudry National Law University. Mr. Smychok will develop on the principles of tax legislation under martial law in Ukraine. Dear colleagues, good afternoon. Thank you for having me here at this event. I will develop on the principles of taxation law under martial law, as well as about the principle of stability and its implementation in the jurisprudence of the Supreme Court as of today. In particular, with regard to taxation of mineral wealth of our country. Why would I choose this topic? That's because starting from April, I was contacted more than once, including by representatives of tax authorities who would ask me, have you seen what happens in the area? Have you seen the ruling of April 19, 2022? What's going on here? The tax authorities representatives would ask me, are we bearing down the principle of legal certainty in this country? That ruling has provoked much discussion in the professional community. And the most flagrant question was whether from now on everybody can do whatever they wish. So as you may understand, my intervention will be built about the above mentioned ruling of the 19 April 2022 in the case 816/8687/16. In my opinion, this case lays down some ice-breaking changes in Ukrainian judicial practice. When I read that ruling for the first time, I was puzzled and perplexed as a lawyer, as an academia. So I went to Article 13 of the Constitution of Ukraine. And after having reread Article 13, I understood to a certain extent the reasoning behind that ruling. I asked myself what I would do if I were a justice of the Supreme Court. What would I do in order to counteract the decrease in budget income? So let me start from the very beginning, namely from Article 13 of the Constitution of Ukraine, which states that the land, its mineral wealth, atmosphere, water, and other natural resources within the territory of Ukraine, the national resources of its continental shelf, and the exclusive maritime economic zone are objects of the right of property of the Ukrainian people. Ownership rights on behalf of the Ukrainian people are exercised by bodies of state power and bodies of local self-government within the limits determined by this constitution. So indeed, constitutional the constitution lays down not only basic legal rules, but are also prerequisites for detailization of concepts in other pieces of legislation. Besides, Article 13 says that property entails responsibility and that property shall not be used to the detriment of the person and society, which seems to be quite logic. Now, in situations where the legislator fails to keep up with social changes and developments, it is the judiciary which is expected and supposed to fill the gaps. And to the best of my understanding, the Supreme Court tried to fill the gap by its ruling of April 19, 2022. In a nutshell, what is the content of decision? The Supreme Court adjudicated the surplus of tax assessment for use of mineral wealth. This surplus was calculated based on the laws of the 31st of July 2014 and 28 of December 2014, which introduced amendments to the tax code of Ukraine. Thus, the rate for use of mineral wealth was increased from 28 percent of the tax assessment to 55%. The taxpayer claimed that the above laws were adopted by the legislation less than 6 months before the new budget period, which violates the principle of stability of tax legislation. This principle is indeed very important and was enshrined in particular in the ruling of February 13 of 2018. In particular, the Supreme Court has reconfirmed this approach more than once, namely in its decision of September 21, 2018, where it mentioned that the tax law in Ukraine shall be based, among others, on the principle of stability, which implies the following. The legislator may introduce new rules changing the existing budget legislation no later than 6 months prior to the new budget period. Second element of the principle of stability is that taxes and levies, their rates and tax allowances cannot be changed during the budget year. So these are these two aspects which mainly constitute the principle of legal stability in case in tax legislation. So once again, amendments not later than 6 months prior to the beginning of the budget period, and no changes of taxes and levies over the period of a budget year. I would say that the principle of legal stability is a constituent part of a broader legal concept of legal certainty. Now, coming back to ruling of the Supreme Court of April 19, 2022. It turned out, according to that ruling, that rules of Article 4.1.9 shall not cancel the rule which changed or amended the tax or any element of the tax, and thus there is no collision between the newly adopted norm and the principle of stability. As the principle of stability shall be applied in systemic correlation with other principles of legal legislation.
Такий підхід, зокрема, також був відображений в окремій думці спільній суддів Верховного суду.
The same approach was presented in additional joint opinion of January 21, 2020 to the ruling of the Supreme Court on consideration of cases on tax administration and collection of levies and other mandatory duties.
Основу принципу правової визначеності. Згідно з усталеною прецедентною практикою Європейського суду з прав людини.
According to the existing case law of the ECTHR, the combination of words established by law implies legal certainty, which means then that when a state authority exercises its powers as established by law, Such an authority shall be guided by the principle of legal certainty. The Strasbourg Court also says that legal certainty, the principle of legal certainty implies clarity and exact nature of legal regulation. And second, predictability and stability of legal regulation. I guess these two aspects may constitute a topic for a scientific discussion which would take much time. But in a nutshell, it gives us a clear understanding that the principle of legal certainty means that the consequences of application of legislation should be predictable and to a certain extent clear for professionals in the area. Thank you very much, Yevgen. Thank you very much for an interesting speech and for respecting the time limit. I think everybody will agree that existing circumstances are of direct impact on what is happening in our country. So the above mentioned ruling of the Supreme Court of April 19, 2022 can hardly be considered out of context of active hostilities and martial law. So hopefully this ruling will become complementary to the principles which exist and apply by Ukrainian lawyers when dealing with tax-related disputes. Now, the next speaker is invited on stage, Vasil Ilkov, judge of Dnipro District Administrative Court, professor who will dwell on procedural peculiarities and consideration of tax disputes under martial law in the court of first instance. Judge Ilkov, the floor goes to you.
Перш за все, дозвольте подякувати за можливість взяти участь.
Good afternoon, colleagues. Thank you for inviting me.
Чудовій міжнародній конференції.
It is indeed a great pleasure and honor to participate in this international event. It has become a good and long-lasting tradition to sit together at this conference and have a discussion which makes available various opinions of esteemed experts and professionals from various countries, and to hold these discussions which are aimed at enhancing knowledge and ideas and experience in the field.
Unfortunately, this conference is special given the conditions of war, but still I'd like to thank the organizers, and still the topic we're discussing today is still relevant, and the topic I picked for this conference is procedural consideration of cases in court. So I emphasize the procedural side of it. And especially the first instance courts. Starting from the 4th of February, starting from the 24th, the state of war has been declared in Ukraine, and for the period of the war, some constitutional rights can be limited, and justice can only be administered by judges. And Article 92 states that under the state of war, the courts, organs of justice, act based on its mandate stated by the Constitution of War, the Constitution of Ukraine. Particularly, it's Article 54, where rights and freedoms of citizens are protected by judges, by courts, and cannot be limited. So courts under the war conditions have to work without any interruptions, and there are certain principles and specific features of how courts consider cases. So limiting forms of administering justice is prohibited. Cases that are not urgent are only considered based on written agreements of all participants. To ensure safety and security of participants, personal meetings are abolished. There's also an issue of submitting an application to consider the case. Video conferencing can be used and is allowed. Now, I'd like to dwell upon each and every item, which includes tax disputes. First, issue of procedural terms. Often, procedural terms need to be extended, as well as some additional procedural actions. And we see that when cases are heard, parties may fail to show up, and then that creates the need to extend the terms, the procedural time frame. In most cases, there could be motions, respective motions to extend the terms, but some legal changes may be required, and adhering to reasonable time frame of court proceedings, because despite the state of war, the court still needs to adhere to the normal time frame. Of course, given the particular circumstances of the case, and taking into account the conditions on site. Next issue, abandoning case consideration. This happens when the party or a third party is located or is taking part in the armed forces of Ukraine. So individuals cannot show up in court because they are part of the armed forces. What's also quite complicated is stopping the person participating in the armed forces, but item 5 of Article 326 is rather complicated. So we need to improve provisions of Part 1, Article 236, and be able to stop litigation for the time of the state of war. As you know, based on the members of parliament's initiatives, bills 7316 and 73/16 have been introduced to Parliament. First one is on the status of judges under the war conditions, and based on information displayed on the Parliament of Ukraine. This bill was passed in as a basis, but there is an issue of notification of parties. Information can be given through the single electronic services portal, including DIA application. So this makes it a lot easier to notify the parties. However, if this bill is passed into law, it will certainly help a lot in the operations of the first instance courts. There's also a bill 73/16, which deals with procedural code. The time frame for considering cases, etc. Based on the information we can glean from the website of the Parliament of Ukraine, the bill was not passed in the first reading, so the issue still remains open regarding amendments to procedural codes. Written provision under the conditions when one party doesn't show up, an important position of a tax authority is to consider the case in writing. The party would always object. And depending on the evidence collected and how many hearings have been held, the court still switches to a written procedure while adhering to all the rules. But if one of the parties do not show up, there could be motions. A party could insist. And so I believe that under war conditions, we need to improve provisions concerning written procedure, making things easier So the position of the tax authority regarding written procedure is quite clear. There's also an interesting position which is supported still today, and that is the need to hand in the written postal information sent by post, a regular post or electronic message. So perhaps we could update the legislation to make it possible to notify people by post, but many bodies lack funds for envelopes and stamps. And so the practice that is supported by Supreme Court of Ukraine is such that when the first instance court is expecting an envelope, we may not adhere to the reasonable time frame due to lack of envelopes. In conclusion, I'd like to draw your attention to the outstanding issues, procedural issues that require attention, conference, video conferencing, for example, is something that is controversial, and many authorities are not supporting this, but we need to optimize the processes during the state of war, and therefore the video conferencing capability gives extra flexibility and additional choices. And so in the future, this could be something that the Parliament of Ukraine could consider. Thank you for your attention, and may peace be with you. Thank you, Mr. Ilkov. Indeed, you raised topical issues in your presentation. Under the conditions of war, indeed, we have difficulty in informing the participants, the parties, adhering to the reasonable time frame, providing security to the parties, as well as the court staff. However, justice still needs to be administered, and it is sad that 73/16 bill was not voted into law, because otherwise conditions could have been adapted and court could be more flexible in using certain provisions. Nevertheless, we need to work under conditions that we have. And now I'd like to give the floor to Tetiana Kolomoets, Dean of Legal Department of Zaporizhia University of Law, PhD, professor. Her topic is targeted gifts to public officials under the state of war. Does it make sense to abolish the value limitation? Because currently, among the Many of the citizens are helping the armed forces of Ukraine, humanitarian assistance, they work as volunteers. Therefore, what do you do if gifts are given to the armed forces of Ukraine? This may be construed uh, in the context, or rather considered in the context of the anti-corruption legislation. Thank you very much for the opportunity to join your conference. I agree with my colleagues that this has become a tradition to hold these conferences, and this is one of the events that raises interest among our colleagues and representatives of the legal profession. They look forward to this seminar every year, and I do agree with the moderator that the issue of the ban of gifts remains topical even under the state of war, but we know that the limitation of gifts serves as an anti-corruption filter, so that we can see that the officials serve public interests, and therefore any grounds and preconditions for illegal use of their authority under standard conditions, gift bans and gift limitations should be differentiated.
Перепрошую, Тетяна Олександрівна, що перерваю. Якщо можна, трошки повільніше, перекладачі не встигають.
Будь ласка, да. Отже, ми говоримо про те, що
So we are saying that under the conditions of war, gift limitations and gift bans are still topical because the person still maintains a special legal state, a legal status under the war conditions. We need to be careful when we analyze this issue. When we extend the state of war, limits on gifts and bans on gifts need to be analyzed in the context of the following. Many of the officials are seeking funds and material for the armed forces of Ukraine, as well as helping people who suffered from the Russian aggression. And under the conditions and this of a huge scale of these people and the amount of gifts and donations given, and even under the condition of war, no one abolished the limitations for gifts, but we need to still look at the periodical indicators, value, and whether the gift being given meets the standard, reasonable hospitality standards, because it needs to correlate with the rules of the state of war. Therefore, we need to now discuss the 7270 bill.
Ще раз підкреслю, не скасовані, а коли ми говоримо на паузу поставлені відносини щодо дотримання подарункових обмежень в частині деяких
In the meantime, we can put on pause the application of certain legal rules regarding value, attribute, reporting, and declaration. Let me underline here, we are talking about putting on pause about suspension rather than cancellation of the above mentioned rules. So imagine the situation where a person, a politician, or a public a civil officer is engaged in support of the army or in humanitarian assistance and receives respective funds to be able to do so. The question is whether funds received can and shall be considered as his or her proper funds. I think that it's clear that it should not be considered as private funds. It should be deemed that if a person transfers all amounts received or all items received in full scale to respective accounts or physically to the needs of respective individuals. If the above mentioned funds and items are transferred in full amount, and here we are talking about quantitative side, quantitative aspect, then an alternative regulation should apply to governing such funds and items. Again, let me underline here that the alternative treatment implies solely during martial law and will be terminated once martial law is levied. The application of the alternative model is expected to be applied on a temporary basis. This is what the legislator said explicitly. Thus, starting from the moment martial law was implemented and until the moment martial law comes to end, the alternative model and the alternative treatment may apply. Now, what else is important here? We are talking about the receipt of items and funds with a specific objective. So we are talking about target funds and target funds, which means that they should be used for military purposes or for humanitarian purposes. So alongside quantitative criteria, quantitative indicator, we also have here the requirement of target use of such funds and items. Thus, if two said conditions are respected, then respective funds and items cannot be considered as belonging to a public officer or to a political figure, and we may talk about legitimate application of the alternative model in such cases.
Перший закон України про запобігання корупції, він є.
Let me underline here that we are using here the word combination, the expression targeted gift, because the term gift exists in Ukrainian legislation, and in order to avoid confusing, in order to avoid overlapping with another area of regulation, we use here the expression, the term targeted gift. So now, again, we are talking about application of temporary provisions here, about temporary legislation. Thank you, colleagues. Tatiana, thank you very much for your very interesting report. Hopefully, the bill mentioned by you will be voted into actual law, into actual piece of legislation, even though it seems that its adoption has protracted. Now we continue with the next speaker, Tatiana Hrychana, acting chairman of the Corporate Taxation Department of the State Tax Service of Ukraine, who will develop on taxation under martial law. Very general topic. Dear colleagues, thank you very much for having me here, and thank you for giving me this opportunity to dwell upon the issue of taxation under martial law. Since the very first day of Russian invasion to Ukraine, the state has been taking measures to adapt the national tax legislation to the needs and challenges of the wartime. In my speech, I would want to highlight the most pressing issues which are of the greatest interest for taxpayers, in particular, failure to comply with financial obligations, with tax obligations during martial law, failure to submit tax reports, rights and scope of powers of tax authorities in terms of inspections and some other issues. So the major law in the area of taxation was adopted on the 7th of March 2022, which amended the mode of legislation of taxation, and the said law exempt those taxpayers who were unable to comply with their tax obligation from liability for the whole period of application of martial law, and 3 months after the martial law. Then the amendment was introduced, prolonging that period up to 6 months. In the meantime, the taxpayers who continued business activities did comply with their tax obligations, and we are very grateful to them for displaying such consciousness and readiness to support their country. Since the war broke out, we collected some 1.5 billion hryvnias of taxes. The taxpayers in whose respect a special regime was offered can be roughly broken into four categories. So the first category introduced by the draft law 2118, and it covers those taxpayers who are unable to comply with the financial tax obligations. They're exempt from liability under martial law, and for the 6-month period after. Then the second group of the second category of taxpayers who had limited possibility to comply with their tax obligations were exempt for liability for 60 days starting from the first day of the month which followed the budget, the reporting period. Now the third category of taxpayers covered taxpayers who continued their business activities but who were unable for certain reasons to pay taxes and who are supposed to do so until the 31st of July 2022. And finally, the four group, the fourth category of taxpayers include taxpayers who are private entrepreneurs of the third group and who switched to 2% rate from 5% rate, and who are exempt from paying VAT for the period of 60 days following the first day of the month, which follows the reporting period. The same law says that the taxpayers who are able to ensure continuity of their business were granted with the possibility to submit declarations and other documents to tax authority with a 60-day delay, counting from the deadline. Now, speaking of the failure to comply with tax obligations, the assessment of whether the taxpayer was able or unable to comply with tax obligations is held on the basis of attribution of a taxpayer to one of the four mentioned categories. The attribution to a category took place on the basis of objective circumstances in which the respective enterprise or entrepreneur found himself or herself. As an example, the facts of destruction or heavy damage of premises equipment, computers, documents of a taxpayer may lead to his or her or its attribution to a category 1, which especially applies to those businesses that used to be located in the areas affected by active hostilities or in the close vicinity to such areas. The list of characteristics for being attributed to one of the 4 categories is not exhaustive, and the each case is assessed individually. In order to be attributed to one of the 4 categories, the taxpayers are expected to submit respective documents attesting their situation until the 21st of August 2022.
З моменту наступного дня періоду місяця, з першого дня місяця наступного за місяцем, в якому в якому з'явилася можливість такого платника виконувати такі податкові обов'язки. Також передбачено
There were different approaches to determining the deadline date, but after discussions, it has been decided that the best solution would be to set up a specific date, which is the 31st of August 2022. So the respective package of document needs to be submitted within the set deadline for the taxpayer to be attributed to one of the categories and to be exempt from liability and from timely compliance with tax obligations. Another big question arising among the taxpayers is about how to submit such documents confirming the lack of possibility to comply with tax obligations. This question is extremely especially topical for those taxpayers who remain in the territories of Kherson region or Donetsk region or Luhansk region, which are under occupation. The solution was suggested in the form of electronic submission. So those who do not have physical, do not have possibility to submit hard copies of documents and to do it physically, can submit them electronically, while those taxpayers who remain on controlled territories have the possibility to go ahead with hard copies.
The controlling body can take a preliminary decision if some documents are missing, and then the documents are sent to the payer so that he can provide additional documentation, and then based on the examining documents, decision is made whether the payer can honor his or her tax obligations with appropriate consequences. Regarding filing the VAT documentation, as we know, in order to protect cyberspace, registration of tax bills has been abolished. In order to pay VAT obligations, Law 2120 was passed, where the payer can include VAT to other payments. The state tax authority posted explanations on their website explaining how tax declaration for VAT should be filled in and what can be attached to it, which streamline the process and help the payers to have a better understanding of what the process looks like. So the taxpayers receive detailed explanation of when renewing their registration system, they will be able to register when the main amount is negative using a special formula. The payers who filed their VAT declarations for March, April, and May, after the 27th of May, they could re-register their tax documents, and when the payer took measures in line with tax code and did that in February, March, and April, by May, they reached the standard formula. Obviously, we can't say that everything functions perfectly, because indeed now payers who have counteragents on occupied territories, they cannot register their tax declarations, and therefore the payer cannot receive many tax documents, and that often creates additional tax burden for the payers, for the taxpayers. And currently, in order to tackle this problem, we are developing ways of solving this and finding alternative solutions. Also, positive decisions in favor of the payer were made. Regarding verifications, Law 2118 stopped all inspections that controlling bodies can make. With adoption of the law of 2120 on 17th of March, changes were made and inspections were made, were carried out, and they can study those declarations that are based on registered tax bills, with the exception of access duty commodities. The code provisions date back to January, but because inspections were suspended, the taxpayers in June received budget compensations for January. Next law, or rather the same law, renewed factual inspections in March. The issue arose that payment discipline had to be verified because we know that in March it was very hard to pay using the bank card, and therefore factual inspections were introduced, and the law 2142 renewed cameral inspection for the single tax payers, group 4, who submitted their declaration by the 21st of February. And as results of this inspection, the payer was included into the single taxpayer fourth group register. With adoption of 2260 law in May, we renewed all the cameral inspections and registration of tax bills, declarations, and timely payments. We also identified special rules for paying VAT, which is to do with budget compensations, because there's the main rule for the payer who can honor their tax duties. The latest term, the maximum term of payment was set as 15th of July, and the law states that the new schedule goes into effect starting from the 15th of June, and in order to ensure or rather rules of the tax code that existed before the law, before the war, there will be 4 inspections of declarations this year, and in August, declaration should be filed in line with requirements of Article 202, which states that cameral inspection should be carried out within 30-day period. I think, please follow the time limitation. I'm sorry. I got carried away. Okay, very briefly. New system of taxation was introduced. This gave an opportunity for business for third group registration. There are no limitations regarding the volume of income, number of employees. There are certain limitations regarding types of activities, and they need to be, the overall volume should be less than the third group. Just to give you an example, from the single taxpayers from the third group, declarations for April and May were filed, and 50 billion hryvnia has been declared, and less than 1 billion hryvnia in single tax payments have been made, and the single tax goes to the local budget. There were many changes, such as waiving payments of VAT, audio books, delaying payments for gas bills. This includes production of gas and filling gas storages. And all of this are honoring their tax duties and ensure contributions to the budget. I thank the opportunity to present my information to you. Thank you for your presentation. We understand that the topic you handled is very expansive, and the parliament indeed introduced many changes to the tax code of Ukraine under the conditions of war to stimulate the economy and streamline processes. It is good to see that you understand that everything, not everything rather, functions perfectly. And I understand that you will be tackling many of the issues yourself, which means there will be less appeals and less applications channeled to court. So litigations will still continue, of course, but we hope to a large degree they can be streamlined. Now I'd like to give the floor to Dmytro Vinokurev, Editor-in-Chief for Taxes and Accounting Journal. He will talk about movement of people and associated business in the tax aspect. Obviously, due to the war and new threats, Ukraine saw a large movement of people. And this is exactly what Dmytro is going to talk about. Good afternoon, dear colleagues. It is my pleasure to join your event. Can you bring your presentation on screen? Yes, it is there. I'd like to dwell upon practical aspects that IDPs encounter and that issues that concern their business. If we talk about business of IDPs, there could be several options. You could be an owner, or you could be a freelancer, self-employed. You could be an IDP within Ukraine, or you could be a refugee leaving Ukraine. And that means issues like residency. But I'd like to stress my attention on movements within Ukraine, a movement of businesses as entrepreneurs. Yet we have many IDPs ask questions they never had to deal with in the past. I have no doubt that over time, some of these issues will make it to court, whereas others could become the topic of research. So I'd like to share some of these with you. Because time is limited, I will only talk about 5 specific situations that are often raised by self-employed people. First, in the tax code, there is a requirement which talks about the following. Imagine a tax agent makes a payment in favor of a self-employed individual, but suppose he is on the temporarily occupied territory. This leads to specific consequences. Tax agent has to receive pay a military fee. So this does not work and does not depend on the type of taxation that the self-employed individual chose. And on many information portals, we see advice to spread this the legislation on companies that work with individuals even on temporarily occupied territories. So almost 20% from payments to self-employed individuals are deducted. Of course, you can re-register on the controlled territory, but not all IDPs do that. In fact, many IDPs simply get registered as IDP, even though they are self-employed. In fact, so what's important is the physical location and registration address. In actual fact, it means that Kherson, Mariupol, and Izium are temporarily occupied territories. That's why the conclusion is often wrong, because to apply the tax code, you need to use terms in normative meaning, if they exist, and they do exist. The list of towns, occupied towns, are also identified by the Cabinet of Ministers of Ukraine. The latest change occurred on the 2nd of February 22, and of course, the latest developments are not reflected in it. Therefore, for the goals of taxation, self-employed individuals registered in Kherson, Mariupol, Melitopol cannot have an address on the temporarily occupied territory. Therefore, a tax agent who makes a payment should not receive a military fee from such an individual. Furthermore, this will not depend on the fact whether the self-employed re-registered on the controlled territory or whether they have received the IDP status. The next issue concerned the consequences for the single taxpayers who conduct business in a location different from their registration address. For example, the registration address is Kherson, but now, in fact, the business is conducted in Lviv. The information about the change of address was never submitted, and oftentimes self-employed people simply receive IDP status, even though tax code requires submission of an application. But what are the consequences if you fail to submit appropriate application? Well, the tax authority stated two things. First, there is no responsibility for failure to apply to submit such an application.
Якщо виявлять порушення вимог глави 1 14 розділу Податкового кодексу, то відбувається
Time the tax authorities say that if the violation of Article 299.11.1 is detected, then the registration of the unified taxpayer registration card will take place. So the annulation is a big problem for the taxpayer, of course. And such a consequence is excessive because the tax code of Ukraine consists an exhaustive list of grounds for the annulment of taxpayer card registration. Of course, it is better for an IDP to provide information on the new place of stay or place of doing business, especially considering that it is quite easy to do that online. However, there should not be any risk of losing the right to simplified taxation regime in case of the failure to comply with the requirement of re-registration. Another major issue which is private entrepreneurs who may not continue their business activities. I think this situation is natural because for some private entrepreneurs, it may be now challenging to continue or reopen business in a new place. My advice would be not to hurry up with the termination of private entrepreneurship, because currently the case burden, the tax burden on private entrepreneurs is equal to zero. The private entrepreneurs are not supposed to pay any taxes, including a unified social fee, if their business activities are suspended. However, there is a but. Once private entrepreneurship is not terminated, then there is a risk of excessive taxation. If the private entrepreneur opts for not terminating his private entrepreneurship, then later on, when he or she finally decides to terminate it, and if he or she receives money from counteragents after the termination of private entrepreneurship, the tax assessment may be calculated from 5 to 19.5% of the income received. So why we are talking about excessive taxation? Because when the person terminates private entrepreneurship, it means that he or she terminates all business activities and has reasonable expectations as to the legal consequences of such act. However, receiving funds after the closure of private entrepreneurship does not depend on ex-private entrepreneur. Thus, the taxation assessment may turn out to be higher than under usual circumstances. So again, my advice would be not to rush into the termination of private entrepreneurship. Now, another question. Private money used for funding of private entrepreneur entertainment enterprise. So some entrepreneurs terminate their activities, but others are making efforts to resuscitate their businesses, and they make influx of their own private money to support their business. But this may lead to taxation of private funds, including for payers of the unified tax. This should not happen, of course, because we are talking about funds that have already been taxed and previously, and that the entrepreneur uses for the resuscitation or support of his business. So imposing taxes on such funds would mean double taxation. Now, another big issue is whether tax authorities may or may not hold inspections and impose fines. The existing amendments to tax legislation clearly state that inspections can be held, but the fines cannot be imposed. But here, the devil is in details. Fines cannot be imposed during martial law. And the tax authorities say that they will impose fines for violations detected during martial law once martial law is levied. In my opinion, such an approach is erroneous. I agree that here we are facing the ill-formulated norm, and here it's the legislator to put the blame on, instead of saying during the period of martial law, they should have used the wording for the period of martial law. In the meantime, I guess that the State Fiscal Service shall review its approach, because otherwise the amendments attenuating tax legislation during martial law would not make any sense. People will anyway be punished for being unable to comply with their tax obligations on time. Maybe not during martial law, but afterwards, which is still unfair. Thank you very much for your attention. I will be happy to answer your questions, if any. Thank you, guys. Thank you. Thank you for sharing your very interesting ideas, Mr. Vinokurov. Indeed, should the participants have questions, they are kindly invited to print them in the chat box or ask them after the intervention of our last speaker for today, Raisa Kanova, Judge, Secretary of the Judicial Chamber on cases on taxes, fees, and other obligatory payments of the Administrative Cassation Court within the Supreme Court. Her topic is issue of taxation under martial law as a subject of court proceedings. Thank you very much. Thank you for introduction and presentations. Dear participants, I understand that it's 5:30 on the clock and we're supposed to stop at 5:45 tonight. So I will not demonstrate my presentation. I will cut down a bit my presentation, which will cover the period of 2014, 2022, and I will speak about the peculiarities of taxation in our country within this period of time. My colleagues, two previous speakers, helped me a bit with presenting what I was thinking to share with you, because they have already covered in very much details what happened in our country after the 24th of February. Since 2014, we have witnessed multiple major changes in the life of our country, which had direct impact on tax legislation in Ukraine. So the first one is the ATO, anti-terrorist operation, which was launched in April 2014. The declaration of ATO entailed the introduction of special measures in the field of taxation. There were two respective laws dating back to autumn 2014. We all expected at that time that the measures would be indeed temporary. The measures aimed supporting businesses which remained on uncontrolled territories, internally displaced people, and private entrepreneurs. As you all know, the temporary nature of this law failed. The laws are in place for 8 years already, even though they underwent a series of modifications. Which means that all related legislation, pieces of legislation and regulations apply. So insofar as they do not contradict the above mentioned law on the introduction of special measures in the field of taxation. The tax code of Ukraine covers various aspects of tax assessment, tax administration, tax enforcement, and the tax code says that it can be amended by voting respective laws.
Території проведення АТО за переліком Кабінету міністрів. З одного боку були врегульовані звільнення від оподаткування законом
The
16.
tax code
Як я вже сказала, про
exempt from payment of taxes, levies, and duties enterprises, including state-owned enterprises and business entities remaining on uncontrolled territories since 2014.
Дії норми права у часі, і ці спори були вирішені на користь платників податків. Треба сказати, що законодавець терміново
Some disputes arose in connection with the failure of the above-mentioned entities to comply with the tax obligations. The claims were initiated by tax authorities, but all disputes were adjudicated in favor of taxpayers thanks to the adoption of the above-mentioned amendments to the tax code of Ukraine.
Цей орган, знову ж таки, за законом 1669, який нібито мав відносний
Now,
рішення, які застосували
the Industrial and Commercial Chamber of Ukraine
підтвердження обставин непереборної сили
submitted its opinion on amendments introduced to the tax code and confirmed the inability of certain business entities to comply with tax obligations by issuing respective certificates.
Тому що платники податків йшли туди, передусім для того, щоб використати
So the chamber would issue such certificates and the taxpayers would go before the chamber in order to obtain such a certificate aiming to obtain exemption from paying taxes and from compliance with other tax obligations. But once the law entered into force, the ICC stopped issuing such certificates because in the opinion of the Industrial and Commercial Chamber, having a respective law in place was sufficient, and there was no need in the issuance of certificates. So the fact where some taxpayers would hold certificates while others don't led to another uncertainty which was addressed by administrative courts. There was a case tried by a Luhansk regional court. The case covered the issue of failure to comply with tax obligations before tax authorities, which also remained in the uncontrolled territories. That was a model case. It was considered by the Grand Chamber. So we considered reconsidered the law on payment of a unified social fee and exempt the above-mentioned enterprises from payment of the unified social fee.
54. Але от таке право застосування.
However, such application of the law had its consequences, and when we saw that this norm was removed, we saw the explanatory note in the Parliament of Ukraine. We saw that there was a direct reference to our model case. The next issue, and people have mentioned this today already, this is the introduction starting from the military duty, starting from 2014. There were some issues regarding the principles of this duty, but we really concerned ourselves with the terms of calculation of this duty. There was no doubt about the need for this, given the circumstances that this country finds itself in. We know that it is currently 1.5%. Now the parliament is lobbying for the increase of this percentage up to 3%, but this duty is aimed at increasing the defense capability of Ukraine, and this will come into effect when the reform of the armed forces of Ukraine is completed. So this fee, this duty has to stay, and why it wasn't introduced into the permanent type list of taxes in the main part of the tax code remains open. It is currently part of transition provisions. There's also an issue of procedural issues of considering cases. They are based on single system, and our chamber acts not only as cassation instance, but we also look into first instance cases, and we have similar situation, people residing in Kherson and Melitopol, for instance, and individuals and businesses from the Russian Federation with whom we severed diplomatic relations. So we already approached the Ministry of Justice because there's a legislation regarding sanctions that doesn't cover this. I did digress about conditions under the state of war and a terrorist operation, despite the fact that this law was updated for 14 times, but it existed until the 1st of May. And after that, the terminology was changed, and now it is called the United Forces Operation. But more norms came later. A taxation code, or the tax code, was amended, and this concerns companies that are located on the occupied territories. So we need to realize whether the legal relations that have to be launched are regulated by this law, and especially the ones that were introduced on the 24th of February. We need to be frank about this, because some taxpayers moved to Ukraine and got registered. Others are registered in so-called Donetsk and Luhansk People's Republic. For instance, Zasyadka mine cannot move the mines to another location, so they are paying taxes in two locations. Some enterprises that cooperate with Ukrainian companies, they even paid VAT, but they never reported to tax authority. We have issues with that. There are also many issues with respect to tax debts, and this debt exists until the 14th of April, and this should also be part of the national program. So we know how to handle this tax debt. Regarding the commission that worked on legislation, we looked for references in the EU legislation. We submitted our proposals to the Cabinet of Ministers of Ukraine, but things are complicated also by the change in the legal regime. And now our tax legislation, tax base is completely different. And both 2120 and 2142 are the bills that need amendments. We could talk about another sphere that works for military capability. So this work is voluminous, but with the help of parties joining and the tax authority, even though it's oversaturated with functions, we understand that the one body holds the control, and they conduct administrative consideration. The body is overloaded, but given the rules of administration and their functions, I think we will rise to the occasion as long as we have peace. And more importantly, I'd like to thank the judges of the first and second instances who, despite difficulties, continued to work diligently between air raid sirens and shelling under conditions of war. This wraps up my presentation. I will circulate my presentation to the participants. We could certainly continue to debate and analyze the three stages of the tax reform. Thank you for your attention. Thank you for your presentation. Thank you for covering some history of administrative litigation pertaining to tax issues. Unfortunately, the situation presents new challenges to us, but hopefully soon we will celebrate victory and by and by, peaceful life will return. We still have 4 to 5 minutes. If there are still some questions left, questions or comments, so this is the time to ask questions if there are any. I don't see any questions in our chat. This probably means that our presenters made good presentations and clarity was there. And as far as some controversial issues is concerned, well, that can be handled in court. I thank all the presenters for their fruitful participation and all the participants of the conference. This was our last session today. I'd like to remind you that tomorrow we have our second day of the conference, and I urge you all to join it tomorrow. Just to remind you, we will resume our work tomorrow at 10 a.m. So please make sure you log in a few minutes early. And the topic of discussion tomorrow is tax disputes regarding international taxation and transfer pricing. So I invite you all, and at this point, I would like to officially close this conference. Okay, goodbye, and we'll see you all tomorrow. Thank you for your participation. All the best to you.